Hillary Clinton confidently called Speaker Mike Johnson a participation trophy to his face, entirely unaware she had just stepped into a devastating constitutional trap she could never escape. She directed this insult to a constitutional lawyer who spent 20 years asking law students questions they could not dodge. He had spent his weekend preparing 5 questions that a Yale law graduate would know the answer to instantly, and wish she did not. Every correct answer was essentially a confession. She could answer and incriminate herself, or she could stay silent and let the country watch a Yale law graduate fail a first-year exam on national television. She chose silence. It was the wrong answer, too. Smash that like button, because you are about to watch the Speaker of the House give Hillary Clinton a constitutional law exam. She was trained to ace it, and you will watch her refuse to pick up the pen. The 11th of June 2025, Room 2141, Rayburn House Office Building. The House Judiciary Committee had convened a hearing on constitutional standards for government records and public accountability. It was a title that sounded like a law school syllabus, because the man who had written it had spent 20 years writing law school syllabi. Speaker Mike Johnson sat in the chairman's seat. It was an unusual arrangement. Speakers rarely chair committee hearings, the way generals rarely lead patrols. But the committee's subject was constitutional law, and constitutional law was what Mike Johnson had practiced for 2 decades before anyone in Washington knew his name. The committee had voted unanimously to invite the Speaker to chair this particular session. Even the Democrats had not objected. They would deeply regret that. Hillary Rodham Clinton sat at the witness table. It was the same table she had faced Senator Kennedy at. Same building, different room, different chairman, different rules. She wore a charcoal suit. Not navy, not black, but charcoal. It is the color of someone who had been to enough hearings to know that dark colors project authority, and light colors project vulnerability, and charcoal splits the difference. She wore a single pearl pin. Her reading glasses rested on the table, not on her face. They were a prop held in reserve, like a tactical tool you keep visible but consciously do not draw. Johnson sat with a single legal pad in front of him. It was yellow-lined, the kind you buy at Office Depot for a few dollars in a pack of 3. It is the kind that constitutional lawyers in Shreveport, Louisiana, use because they work, and because spending money on expensive stationery is a character flaw that people in Northwest Louisiana do not forgive. Clinton looked at him the way she had looked at every questioner in every hearing for 30 years, with the calm, practiced evaluation of a woman measuring the distance between herself and the nearest threat. She had faced Kennedy's folksy humor and survived. She had faced Senate committees and survived. She had faced Benghazi panels and survived. She decided quickly, the way she decided everything, that the man in the chairman's seat was not a threat. He was the least experienced speaker in 140 years. He was the 4th choice, the one nobody else wanted. He was a constitutional lawyer from Shreveport who had never argued before the Supreme Court, never clerked for a federal judge, and never practiced at a firm that anyone on the East Coast had heard of. She opened her mouth. Mr. Speaker, with all due respect, and I mean that sincerely, you are the least experienced speaker in 140 years. Her voice carried the weight of someone who had spent decades in rooms where experience was currency, and she had more of it than anyone. You have been in Congress for fewer years than I spent as Secretary of State alone. You practiced law in Shreveport. I practiced law at the Yale Law Clinic, at the Children's Defense Fund, at the Rose Law Firm, and in the White House counsel's orbit. She paused, not for breath, but for effect. Clinton's pauses were calibrated the way heavy equipment is calibrated to land at a specific point with a specific yield. Before you lecture me on constitutional standards, perhaps consider that some of us have been applying them at the highest levels of government, while you were filing briefs in Bossier Parish. She was not finished, and I will note that your primary qualification for the speakership was not competence. It was that nobody else wanted the job. You were the fourth choice, Mr. Speaker, the participation trophy speaker. The hearing room shifted. It was the sound of 200 people recalibrating. Clinton's aide typed frantically on her tablet. The gallery murmured. The insult was specific. It was researched and designed to establish a strict hierarchy. Yale over LSU. Washington over Shreveport. Secretary of State over constitutional lawyer. And experience over inexperience. At the chairman's seat, Mike Johnson did something that no one in the room expected. He picked up a pen, uncapped it, and wrote something on his yellow legal pad. Just 2 words. Then he looked up at Clinton with the expression of a man who had just been handed exactly the opening he needed. Because Clinton had made a mistake. It was a specific, tactical mistake that only a constitutional lawyer would recognize. She had attacked his credentials, and she had explicitly listed hers. Yale, Rose Law Firm, Children's Defense Fund, Secretary of State. She had drawn a hard line between Shreveport and Washington, between LSU and Yale, between Bossier Parish and the world stage. And in doing so, she had established on camera, for the record, voluntarily, that she was one of the most legally educated people in America. This meant that every legal question Johnson was about to ask her was a question she had no excuse not to answer. She had confidently walked into the exam room and announced that she was the smartest person in it, and the teacher was about to hand her the test. "Madam Secretary," he said, and his voice was not loud, not soft, not folksy, and not sharp. It was the voice of a man who had stood in front of classrooms for 20 years and learned that the most powerful sound a teacher makes is the sound of pure patience. "Thank you for the resume. It is impressive. Yale Law, 1,973. Rose Law Firm, Children's Defense Fund, Secretary of State." I wrote it all down. He held up the legal pad. 2 words were visible, written in the block capitals of a man who had drafted legal briefs by hand for 2 decades. Pop quiz. "Since you have reminded me of your qualifications, Madame Secretary, I would like to test them. 5 questions on constitutional law. It is the kind I use to give first-year students at Liberty University." He set the pad down. "I am confident a Yale Law graduate will find them straightforward." He looked at the committee, then back at Clinton, and said the phrase that would become the rhythm of the next 30 minutes. It was the phrase that the audience at home would come to recognize as the sound of the next blow arriving. "Let me walk you through the first question." Johnson's voice settled into a rhythm that the hearing room would come to recognize over the next 30 minutes. It was the rhythm of a teacher who has given this lecture 1,000 times and knows exactly where the difficult parts are, because the difficult parts are where the students go quiet. 18 U.S.C., Section 2071, the Federal Records Act. "Madame Secretary, you studied this at Yale. You applied it at the State Department. So here is my question. It is the kind I used to ask first-year students who had not done the reading, except I know you have done the reading because you lived it." He looked at her, not aggressively, but curiously. It was the way a teacher looks at a student who is about to be asked a question the teacher already knows the student can answer. Under 18 U.S.C. Section 2071, what is the penalty for the willful concealment, removal, or destruction of federal records? The hearing room went quiet. Not the dramatic quiet of a Kennedy punchline, but a different quiet. The quiet of a room that had just realized the question was not rhetorical. Johnson was waiting for an answer. He was waiting the way a professor waits after posing a question to the class, patiently, silently, with the understanding that the silence itself is instructional. Clinton's eyes moved downward, not to her notes, as her notes were to her left. Her eyes went down to the surface of the witness table, to her own hands resting flat on the oak. It was the gesture of a student who knows the answer and knows the answer will hurt. Her lips pressed together, not the political smile. The political smile was a weapon, and this was not a moment for weapons. This was a seal, lips pressed tight to keep the words inside, the way you press a lid on a container to keep what is inside from spilling. She knew the answer. Everyone in the room who had attended law school knew she knew the answer. The answer was 3 years of confinement, and the part that mattered more than the time away was disqualification from holding any office under the United States. Say it out loud. And she would be reciting her own potential sentence on C-SPAN. She chose silence. 3 seconds. 4. 5. Johnson nodded. It was the nod of a teacher who has watched a student leave an answer blank and understands why. I will answer it for you, Madam Secretary. His voice was gentle, almost kind. It was the way a teacher is kind when delivering a failing grade to a student who could have passed. The penalty is up to 3 years of confinement and disqualification from holding any office under the United States. He let the statute hang in the room. You knew that. You knew it when you set up a private email server in the basement of your home in Chappaqua. You knew it when your team used military-grade data-clearing software to wipe 33,000 emails. And you knew it when a reporter asked you about it, and you said on camera to the American people, "What? Like with a cloth?" He paused. Senator Kennedy asked you about that quote. He made it funny. He brought up the fishing and the cloth. It was a good line. I am not going to make it funny, Madam Secretary, because it was not funny. It was a Yale law graduate pretending not to understand a statute she memorized in her first semester. That was not confusion. It was a performance. And the audience was the American people. And they deserved better than theater from someone who swore an oath to serve them. Johnson set his pen down. What came next was not a legal question. It was personal, and the hearing room felt the shift. It was not in his voice, which stayed at the same patient frequency, but in his posture. He leaned back slightly. It was the posture of a man about to speak, not as a lawyer, but as a son. My father was a firefighter in Shreveport, Louisiana, Engine Company 10. On the 3rd of November 1984, he responded to a structure fire on Linwood Avenue, a warehouse. The building was fully involved when he arrived, flames through the roof, and smoke visible from 3 blocks away. His friend and fellow firefighter, a man named Russell, was already inside. Johnson's voice did not waver. It did not soften into sentimentality. It stayed level. It was the level of a man who had told this story enough times to have moved past the emotion of the telling, leaving only the facts, which were heavier than any emotion could be. The building collapsed. Russell perished inside. My father suffered thermal injuries over 40% of his body. He spent 8 months in the hospital. Reconstructive procedures, 17 of them. 17 times a surgeon transferred tissue from one part of his body and stitched it onto another. He was 32 years old. My mother was 29. I was 12. My 3 younger siblings were 10, 7, and 4. He paused. Not for effect, but for accuracy. Because the next part was the part that mattered. He never worked again as a firefighter. Not because he did not want to. He tried twice, once at a desk job the department offered, but his back could not handle sitting for more than an hour because the procedures on his lower back had not healed right, and would not heal right. Once at a hazmat consulting job, which he kept for a few years, until his body said no. He founded a non-profit, the Percy R. Johnson Byrne Foundation, because if he could not fight fires anymore, he could at least teach other firefighters how to survive them. He ran it from his living room, from a chair with extra foam padding, because regular chairs caused severe physical discomfort. He spent the rest of his life in that chair. Johnson's voice stayed level. The level of a man who had told this story through 30 years of carrying it in physical hardship. Real hardship, the kind where you cannot sleep because the sheets touch the sensitive areas, and they have not healed, and will not heal. Not fully. Not ever. The kind where your 1-2-year-old son learns not to hug you too hard, because a hug on those areas is not a comfort. It is a risk. I learned that at 12. Most kids learn to hug gently because they are told to. I learned because I saw my father flinch. He looked at Clinton. My father took an oath. Not the same oath you took. Firefighters swear to protect lives and property, not to support and defend the Constitution. But the principle is identical. When you take an oath, you do not get to decide which parts apply to you. You do not get to choose which emergencies you run into. You do not get to build a back door before you go through the front. He paused. My father ran into a burning building on Linwood Avenue because that is what the oath required. He did not check whether the building was politically convenient. He did not ask whether running in would help his career. He went through the front door, and the front door cost him his physical well-being. Johnson looked at Clinton, and here his voice carried something new. Not anger, not sadness, but clarity. The clarity of a comparison that required no explanation. You took an oath, too. Madam Secretary. Every Secretary of State raises their right hand and swears to support and defend the Constitution of the United States. You took that oath, and then you built a back door, a private server, a private email system, a shadow communications network designed to conduct the public's business where the public could not see it. My father honored his oath, and it cost him everything. You broke yours, and it cost you nothing. Clinton's head, which had been nodding gently and automatically the way any decent person nods when hearing about a first responder's sacrifice, stopped. Not suddenly, not with a jerk. It froze mid-motion, halfway between a nod and neutral, in a position that had no name. It was the position of a person caught between two reflexes that could not coexist. Keep nodding, and she was agreeing that she broke her oath. Stop nodding, and she was acknowledging that she heard the comparison and chose to reject it. She froze. Head still tilted 2 degrees forward, locked in the space between courtesy and confession. Her left hand rose to her neck, touched the pearl pin at her collar, not adjusting, just touching, the way a person touches a rosary, or a ring, or any small familiar object, when every other familiar thing has been taken away. Fingers on pearl. Self-soothing. C-SPAN camera 2 caught it in full frame. The hand of the most powerful woman in American political history, reaching for a piece of jewelry the way a child reaches for a blanket. Let me walk you through the next question. The phrase was, becoming a rhythm. Let me walk you through. Johnson's version of Kennedy's glasses cleaning. Vance's let me be honest. Tulsa's folder opening. Every protagonist has a tell. Johnson's tell was the phrase of a teacher opening the next chapter of a textbook. 5 U.S.C. Section 552. The Freedom of Information Act, FOIA, signed by Lyndon Johnson in 1966. No relation. A small, dry smile. The only humor Johnson would show all day, and so brief that it vanished before the camera caught it. FOIA exists because the founders believed a basic principle, that the government belongs to the people, not the other way around. that the governed have the right to see what the government does in their name. He looked at Clinton. When you set up a private email server, you did not just violate a record statute. You reversed that relationship. You decided that the people work for you, that the public's right to know extends only as far as you allow it to extend. That is not a records management issue, Madam Secretary. That is a constitutional issue. It is the difference between a public servant and a sovereign, and the Constitution is very clear about which one you are. He turned a page on his legal pad. Let me give you a specific example. After the 2010 earthquake in Haiti, the international community pledged $4.4 billion to rebuild the country. The Clinton Foundation played a central role in distributing that aid. You were Secretary of State, the person approving aid disbursements. Your husband was UN Special Envoy to Haiti, the person coordinating international reconstruction. The foundation received donations from contractors seeking reconstruction contracts. 3 roles, 1 family, $4.4 billion. He paused. The result, 6 permanent homes, $4.4 billion, and 6 homes. A catfish farmer in Breaux Bridge, Louisiana, has a better return on investment. But that is Senator Kennedy's line, and I will not steal it. The faintest ripple of laughter, and Johnson let it pass without acknowledging it. The way a teacher lets a classroom joke pass, because stopping for it breaks the lesson. What I will say is this. When Haitian citizens, the people your foundation was supposed to help, filed FOIA requests to understand how aid decisions were made, how contracts were awarded, why $4.4 billion produced 6 permanent homes and a luxury hotel and a garment factory that created a fraction of the promised jobs. Those requests hit a wall, because the emails containing those decisions were not in the State Department archives. They were on a server in your basement in Chappaqua. Between your water heater and your Christmas decorations, he let the image sit. Not a metaphor, a physical reality. Somewhere in Chappaqua, New York, in the basement of a house owned by a former president and a former Secretary of State, a server containing the aid records of the poorest nation in the Western Hemisphere sat next to holiday decorations, and the people of Haiti, the people who had lost 316,000 lives in the earthquake, the people who were supposed to be rebuilt, could not read their own records, because those records were filed under private correspondence, in a system designed to be unreachable by the law that guaranteed their right to reach it. The people of Haiti could not access their own aid records because you decided those records belonged to you. A constitutional lawyer in Shreveport would call that obstruction of democratic process. What would a Yale law graduate call it? Madam Secretary. Clinton turned. Not a lean, as Kennedy had gotten the lean. This was a full turn, shoulders rotating 15 degrees toward her aide, eyes searching, mouth open half an inch. The beginning of a question she would not ask out loud, because asking your aide for help on camera is the political equivalent of calling a friend on a game show. The aide, the Georgetown MBA, looked back at her, and the aide's face told a story in 2 movements, eyes slightly wider than normal, and a headshake so small it was almost theoretical. The message was wordless and complete. I have nothing for you. There was no page in the briefing binder that answered, why could not Haitian mothers read their own aid files? There was no talking point for that. There was no pivot. Clinton turned back slowly. The turnaway had taken 1 second. Fast, hopeful, the speed of a person reaching for a lifeline. The turn back took 3 seconds. Slow, empty-handed, the speed of a person who reached and found nothing. The difference between those 2 speeds was the body language of disappointment, and the hearing room saw it, and the hearing room understood. Let me walk you through the law on classified information. Johnson picked up his pen, drew a line on the legal pad. a horizontal line dividing the page in two. On the left side, he wrote 2 words. On the right side, 2 more. He held the pad up so the cameras could see. Left side extremely careless. Right side grossly negligent. 18 U.S.C. Section 793. F prohibits gross negligence in the handling of national defense information. 110 emails on your unsecured server contained classified information. 8 email chains were classified at the top secret SAP level, special access programs, the highest classification in the United States government. Information so sensitive that even its code names are classified. Information that career intelligence officers access in specially constructed rooms called SCIFs. Rooms where phones are confiscated, windows do not exist, and walls are built to defeat electromagnetic surveillance. He paused. You accessed that same information on a server that shared a basement with your water heater. A server administered not by the NSA, not by a government security team, but by a private IT contractor from Colorado, who had no security clearance at the time of his initial work on the system. He tapped the left side of the line. FBI Director James Comey, who recommended against prosecution, described your conduct as extremely careless. He tapped the right side. Grossly negligent is the statutory language that triggers legal liability. He held the pad between the 2 phrases. In 20 years of practicing constitutional law, Madame Secretary, I have learned that the distance between extremely careless and grossly negligent is the distance between a parking ticket and a major legal violation. The words sound similar. The consequences are not. One gets you a fine, the other gets you a federal sentence, and in this case, the FBI director looked at the evidence. 110 classified emails, 8 top-secret chains, data clearing software, a private server in a basement, and decided it was a parking ticket. He set the pad down. You drove home. A sound came from Clinton, short, involuntary, expelled through the nose. A laugh. Not the political smile, not the practiced chuckle of 1,000 fundraiser dinners. A real laugh. The brief, reflexive laugh of a lawyer who has just heard a legal argument so cleanly constructed that the craftsman in her cannot help but appreciate it, even as the argument is being used to dismantle her. Parking ticket versus serious charge was good. She knew it was good. Stanford undergrad and Yale law had trained her to recognize good legal construction the way a musician recognizes good composition. Involuntarily, professionally, regardless of whether the composition is playing for you or against you. The laugh died instantly, because she saw the red light on camera 1 and understood in the fraction of a second between the laugh and its end that she had just laughed about classified emails on national television. The clip was already being made in her mind. Her face, the laugh, the sound spliced against Johnson's parking ticket versus serious charge, played on loop forever. Her face closed, not gradually, all at once, like shutters dropping on a window, from laugh to neutral in under a second. The transition was so fast it looked mechanical, inhuman, like watching someone switch off a light, and the unnaturalness of that transition would become the clip, not the laugh itself, but the erasure of the laugh. The visible moment when Hillary Clinton's face went from genuine human reaction to political mask in 0.8 seconds. Her aide slid a piece of paper across the table. Clinton looked down, read it, and did not use it. The paper said, "Invoke executive privilege." But executive privilege does not apply to a private citizen testifying before a congressional committee, and Clinton knew that, and the aide knew that, and the paper was the action of a person who had run out of options but still needed to look like they were doing something. Additionally, Johnson continued, his voice unchanged, He had not reacted to the laugh, had not paused for it, and had continued teaching the way teachers continue when a student makes a noise. Senator Grassley has discovered that the FBI never completed its review of all thumb drives containing copies of your emails. In 2025, there are devices that have never been opened. A constitutional lawyer in Shreveport would call that an incomplete investigation. A first-year student would call it obstruction by delay. I will let the American people decide what to call it. Last question, Madam Secretary. Johnson turned to a fresh page on the legal pad. The yellow pages that had been turned were visible. Notes, statutes, the pop quiz header from the beginning, a visual record of the exam, 5 questions, 5 articles of constitutional law, and now, the last one. Article 1. Sections 2 and 3 of the Constitution grant Congress the power of oversight over the executive branch. That power includes the authority to issue subpoenas and preservation orders for government records. This is foundational. Without this power, Congress cannot perform its constitutional function. Without this power, the executive branch operates without accountability. The founders understood that power without oversight is tyranny. That is not my opinion. That is Federalist 51. He looked at Clinton. Let me walk you through a timeline. The phrase, again? But this time it carried a different weight. Because this was not a statute or a principle. This was a sequence of dates. And dates do not argue. Dates just sit there in order and tell you what happened. The 4th of March, 2015. The House Select Committee on Benghazi issued a subpoena for your emails. Simultaneously, a preservation order was issued, requiring that all relevant records be maintained and protected. He paused. Wrote on the pad, March 4th, March 25th, through the 31st of March 2015. Your technical team used data clearing software to permanently erase emails on the private server. He wrote, March 25th to 31st. He drew an arrow between the two dates. 21 days between the order to preserve and the decision to erase. 3 weeks. He looked at the committee, then at the gallery, then at the cameras, because this next part was not for Clinton. It was for the 40 million people watching at home who had never heard the word spoliation and were about to learn it. In constitutional law, we have a name for erasing evidence after a preservation order has been issued. The name is spoliation. I am going to explain what that means because it is important and because they do not teach it on cable news. He held up the legal pad where the two dates and the arrow were visible. Spoliation triggers what lawyers call an adverse inference. Here is what that means in plain English. When a person erases evidence after being told to keep it, the law presumes, not suspects, not considers, presumes that whatever was erased was harmful to the person who erased it. The burden of proof flips. You do not have to prove the evidence was damaging. The person who erased it has to prove it was not. He set the pad down. Think about that for a moment. If you delete a text message after a judge tells you to keep it, the court assumes the text was bad for you. That is the law for every American, every citizen, every defendant, every company, in every lawsuit, in every courtroom, in every state. He looked at Clinton. 33,000 emails deleted 3 weeks after Congress ordered them preserved. In any courtroom in Shreveport or Bossier or Monroe or any of the parishes I practiced in for 20 years, that is spoliation. That is an adverse inference. That is the legal system saying, we do not know what was in those emails, but we know you erased them when you were told not to. So we are going to assume the worst. That is not my interpretation. That is black-letter law, the kind they teach at Yale. Clinton's right hand, the hand that had been still for 25 minutes, resting flat on the witness table, moved toward the water glass, a trajectory that everyone in the room recognized because they had seen it before in the Kennedy hearing, when Clinton had used the water glass as a delay tactic and the whole country had watched her do it. The hand stopped 2 inches from the glass, hovering. Because reaching for the glass now was reaching for a pattern that had already been exposed. The audience had seen the Kennedy hearing. The audience knew what the water glass meant. And Clinton, who had survived 30 years by never making the same mistake twice, recognized mid-reach that she was about to make the same mistake twice. The hand hung in the air for 2 seconds, not moving forward, not pulling back, suspended between action and inaction, between thirst and strategy, between the body's need for something to do and the mind's recognition that everything the body could do had already been catalogued and decoded by 40 million people watching at home. She lowered her hand flat back on the table beside the glass, not on it, the hand of a person who had decided that doing nothing was the least bad option available, which is not a decision anyone makes when they are winning. Johnson stood, not dramatically, the way a teacher stands at the end of a lecture, the standing that means we are done with the material, and now I am going to tell you what it means. Madam Secretary, I have asked you 5 questions today. 5 constitutional questions: records law, oath of office, FOIA, classified information handling, congressional oversight. He counted them on his fingers. 5 fingers, 5 questions, 5 articles of a constitution that the woman at the witness table had sworn to defend, and had not. In 20 years of teaching constitutional law, I graded thousands of exams, and I always told my students the same thing on the first day of class. The grade does not measure what you know. It measures what you do with what you know. He looked at Clinton. You know the law, Madam Secretary. Yale taught you well. You can cite every statute I mentioned today. You know what 18 U.S.C. Section 2071 says about records preservation. You know what gross negligence means under Section 793. You know what spoliation means. You know what adverse inference means. You know all of it. He paused. The longest pause of the hearing. Not for drama, but for accuracy. Because what came next needed to be precise. The problem was never your knowledge. The problem is that you knew all of it. Every statute, every principle, every safeguard the founders built into the Constitution to prevent exactly what you did. And you broke them anyway, not out of ignorance, not out of carelessness, despite what Director Comey called it, out of the belief that they did not apply to you, that the Constitution was a set of rules for other people, that the law was a structure you could walk around because you were Hillary Rodham Clinton, and the structure was for people who practiced law in Shreveport. He paused, let the word Shreveport hang, because Clinton had used it first in her insult, filing briefs in Bossier Parish. She had wielded Shreveport as a weapon against him, and now he was handing it back reloaded. You mentioned Shreveport in your opening statement. Madame Secretary, you meant it as an insult. You meant to say that Shreveport is small and Yale is big, and the distance between them is the distance between you and me. You are right about the distance, but you have it backwards. The distance between Shreveport and Yale is not the distance between lesser and greater. It is the distance between a place where people honor the law because they believe in it, and a place where people learn the law so they can get around it. He picked up the legal pad, looked at it. Pop quiz at the top. 5 questions below, all unanswered. In my classroom, that is not an F. An F is for students who do not understand the material. What you did is worse than an F. You understood the material perfectly. You just decided it was beneath you. He set the pad down. "I do not have a grade for that, Madam Secretary. I just have a question." He looked at her, eye to eye. The distance between the chairman's seat and the witness table was 8 feet, and those 8 feet were the longest hallway in Washington. If the Constitution does not apply to a former Secretary of State, who does it apply to? Clinton's mouth opened half an inch. Not enough to speak, enough to show the beginning of speech, the formation of a word that never arrived, and then it closed. Not the way a mouth closes when a person decides not to speak. That is gradual, a settling. This closed the way a door closes when someone realizes that every room behind every door contains the same thing. "I disagree" meant arguing with the Constitution, not with Johnson. It is more complicated than that meant a Yale law graduate asking for partial credit. "I have addressed" this meant failing the same exam twice. Every answer was a wrong answer. Not because Johnson had rigged the test, because the test was the Constitution, and the Constitution does not have a curve. She closed her mouth. And for the first time in the hearing, for the first time in perhaps years, Hillary Rodham Clinton looked exactly like what Mike Johnson had described, a brilliant student who understood the material perfectly and chose not to do the work. Johnson spoke once more, quietly. The volume of a man finishing a prayer. "My father did not have a law degree. He had a high school diploma and an oath. Shreveport Fire Department, Engine Company 10. He honored every word of that oath, even when it cost him his physical well-being and the rest of his life in hardship. You had Yale law and the same oath, and you treated it like a suggestion." He sat down, gave the hearing a recess. The gavel hit once, not hard, not soft, the exact force of a teacher closing a textbook, and the sound of it traveled through room 2141 the way a grade travels through a student's life, quietly, permanently, and without appeal. The first clip was the one nobody planned for. Not parking ticket versus serious charge, though that became the most shared legal analogy of the decade, replacing two-tiered justice in the national vocabulary because it was more specific, more visual, and came from a constitutional lawyer instead of a cable news pundit. Within 48 hours, parking ticket or serious charge was being asked about every political scandal in America. A senator under investigation for insider trading, a governor accused of misusing campaign funds, a federal judge who failed to disclose gifts. In each case, the question was the same. Is this a parking ticket? Or is this a serious charge? And who gets to decide? Not ran into a burning building, built a back door. Though that phrase was adopted by every fire station, police precinct, and EMT dispatch in the country within a week. First responder communities, people who take oaths and honor them at the cost of their bodies, heard Johnson's father's story and recognized it as their story. Bumper stickers appeared, some run in, some build back doors, T-shirts at fire department fundraisers, a banner at the IAFF National Convention. The firefighter's son had spoken for every firefighter's family, and they heard him. The first clip, the one that broke everything, was the laugh, 0.8 seconds. That is how long it took Clinton's face to travel from genuine laughter to political mask after parking ticket versus serious charge. Someone timed it. Someone always times it. And 0.8 seconds became a number, the way 148 had become a number in the AOC hearing. A unit of measurement, a tool. How many seconds does it take Hillary Clinton to stop being human? Answer, 0.8. The clip played in slow motion on every platform, the laugh emerging, real, involuntary, human, and then the shutters dropping, the face closing, the mask returning. 0.8 seconds of Hillary Clinton being a person, followed by a lifetime of being a politician, 34 million views in 3 days. Not because it was mean, because it was true. The mask was real, and for 0.8 seconds, the country saw what was behind it. Someone put the clip to music, a pianist playing a single note, sustained, then cut. The note was the laugh. The silence was the mask. The video got 11 million views on TikTok alone and spawned a trend. People filming themselves laughing at something real, then cutting to their professional face. The trend was called 0.8 seconds, and it ran for 3 weeks across every platform. And every instance of it was a reminder that the most powerful woman in American politics had accidentally shown the world the distance between who she was and who she performed. A psychology professor at Stanford, Clinton's undergraduate alma mater, published a thread analyzing the 0.8-second transition as a textbook example of effective override. The moment when genuine emotion is overridden by strategic self-monitoring. The thread was cited in 14 news articles. The professor's conclusion, the speed of the transition, under 1 second, suggests a lifetime of practice. This is not a person who sometimes wears a mask. This is a person who lives in one. Legal consequences heavy. The spoliation timeline, subpoena March 4th, erasure March 25th through 31st, was presented to a federal judge in the District of Columbia, who signed an adverse inference order, first time in American history that an adverse inference had been applied to a former cabinet-level official. The legal meaning, every deleted email was now presumed to have been harmful to Clinton, unless she could prove otherwise. The burden of proof had flipped. 30 years of you cannot prove what was in the emails was over. Now the question was, prove they were innocent. And she could not, because they were deleted. And deletion was the reason for the inference, and the inference was the consequence of deletion. A perfect legal circle with no exit. Grassley's thumb drives, the ones the FBI had never opened, received a federal court order mandating full review within 30 days. The FBI complied. 3 thumb drives contained email chains classified at the top-secret SAP level that had never been reviewed by any investigative body. The DOJ confirmed in a 2-sentence statement, the materials are relevant to ongoing investigations. No further comment at this time. 2 sentences, 14 words. The most ominous 14 words in Washington. DOJ expanded the Haiti audit to full scope. Every contract, every FOB designation, every friend of Bill email, the $4.4 billion, 6 permanent homes, the math that Kennedy had made funny, and Johnson had made constitutional. Elon Musk tweeted the spoliation timeline and added, she deleted the receipts 3 weeks after being told to keep them. In any company I have ever run, that is not careless. That is a firing and a lawsuit. The Clinton Foundation received formal notice of an IRS audit. The first federal-level audit since 2018. The scope: all Haiti-related disbursements, all FOB-designated contracts, all communications between the Foundation and the State Department during Clinton's tenure, the communications that were on the private server, the communications that were deleted, the communications that were now subject to adverse inference. Career clinical end. Georgetown University canceled Clinton as commencement keynote speaker for 2026, not because the administration wanted to, because 1,200 law students filed a petition citing spoliation and adverse inference, and the specific statutes Johnson had taught during the hearing. Law students used Johnson's constitutional law lesson to remove Clinton from their law school. The irony was so perfect it did not need commentary. Clinton, Global Initiatives, 2026 calendar, empty. Not postponed. Empty. No sponsors. No speakers. No donors willing to share a stage with a woman who had just failed a constitutional exam in front of 40 million people. Simon & Schuster invoked the moral clause in Clinton's $3 million book advance and canceled the contract. First time in publishing history that a major house canceled a contract with a former presidential candidate. Clinton's literary agent called it unprecedented. Johnson's press office called it the grade. Speaking fees, which had declined after the Kennedy hearing from $250,000 to near zero, reached a new status. Not declined, but non-existent. No organization made an offer. The market did not shrink. The market disappeared. The last speaking engagement on Clinton's public calendar was a virtual appearance at a women's leadership conference in March 2025. After the Johnson hearing, the conference retroactively removed the video from their website. Yale Law School, Clinton's own alma mater, assigned the Johnson hearing as course material in its professional responsibility seminar. The professor told the Yale Daily News, "The hearing is a masterclass in what happens when knowledge is separated from integrity. We do not use it to attack Secretary Clinton. We use it to teach our students that knowing the law and following the law are two different things." Speaker Johnson made that distinction clearer than any casebook I have ever assigned. Clinton was now a case study at the law school that made her. The building where she had learned constitutional law was now using her as an example of what happens when you learn constitutional law and decide it does not apply to you. A student in the seminar, a second year from Ohio, posted on social media, "We spent 90 minutes analyzing the Johnson hearing today in professional responsibility. The professor never used the word guilty. She did not need to. The Constitution said it for her." The Shreveport versus Yale comparison, which Clinton had intended as an insult, became the defining narrative of the hearing. Not because Johnson had defended Shreveport, because Johnson had reframed the comparison. The distance between Shreveport and Yale is not the distance between lesser and greater. It is the distance between a place where people honor the law because they believe in it, and a place where people learn the law so they can get around it. That sentence was quoted in 340 news articles in the first week. The Shreveport Times ran it as a front-page headline. The LSU Alumni Association printed it on T-shirts. A billboard appeared on I-20 outside Shreveport, paid for by an anonymous donor, featuring the quote in white text on a blue background. No name, no logo, just the words. Everyone in Northwest Louisiana knew who said them. You just heard Speaker Johnson ask 5 constitutional questions. Hillary Clinton did not answer a single one. Not because she did not know, because every correct answer was a confession. But here is what they do not want you to know. The hearing ended, the cameras turned off, and 3 cases are still open. 1. The DOJ still has not finished reviewing the thumb drives that Senator Grassley found. 3 of them contained top-secret emails that had never been seen by any investigator. A federal court ordered full review within 30 days. The clock is ticking. If nobody watches, the clock stops. 2. DOJ is auditing the full $4.4 billion in Haiti aid. Every friend of Bill contract. Every dollar that went to luxury hotels instead of permanent homes. For the first time in 15 years, someone is following the money. If nobody watches, the money trail goes cold. 3. The spoliation timeline that Speaker Johnson read. Subpoena on March 4th. Emails destroyed March 25th through 31st has triggered the first adverse inference order against a former cabinet official in American history. That means the law now presumes those deleted emails were harmful to Clinton. But an adverse inference order is only as powerful as the investigation behind it. If nobody watches, the investigation dies in a filing cabinet. 3 open cases. All of them need one thing: people who refuse to look away. Because Hillary Clinton has survived for 30 years, not because she is innocent, because not enough people were watching, not enough people remembered, not enough people shared. You just watched. You just heard a constitutional lawyer from Shreveport ask a Yale law graduate the questions she has been dodging for a decade. You heard the silence, where the answers should have been. The question is, are you going to look away? Subscribe. Share this video with one person who still thinks extremely careless is an acceptable description for 110 classified emails on an unsecured server. Drop failed the exam in the comments if you agree that knowing the law and breaking it is worse than not knowing it at all. And hit that notification bell, because when Grassley opens those thumb drives, you are going to want to know what is inside. The exam is over. The grade is in. But the verdict, the real verdict, the one that matters, is not Johnson's to give. It is yours. If the highly educated architects of our political system truly believe they are completely exempt from the very laws they swore to uphold, who is left to hold the ultimate gavel of accountability in America?